Hello everyone, I am Dr. Atul Kumar Pandey, Assistant Professor in NLU Bhopal. I am going to discuss module on digital signatures and electronic signatures. The learning objectives behind these modules are to be able to understand the technical and legal aspects of the digital signature and also to understand its use and its validity in the electronic transactions. As we know that in cyberspace voluminous amount of business transactions are taking place, as we also know that law believes in authenticity. So, point of debate is how to create authenticity in such e-commerce transactions, how to protect the rights of the parties to the transactions where hackers and manipulators are innumerable. Digital signatures and electronic signatures offer solution to this problem. The element of authenticity, integrity and non-repudiation are all elements that allow for trust to be placed in the documents or communication. Here integrity means safeguarding the accuracy of the data which is in the transmission or which has been stored at a database. In the real world there are numerous indicators of trust that one can rely on. In the electronic realm, none of these indicators of trust can be utilized, which are very much useful in the physical environment. One can type one's initial at end of the email, but it would be quite unreliable as an indicator of the source. As a result, one form of electronic signatures, digital signatures using public key cryptography has been developed to meet the requirements of the authenticity, integrity, confidentiality and non-repudiation. Here confidentiality means that data should be made available to those persons who are authorized to have access to that data. It should not be accessible by those who are not authorized or who are not entitled to secure access to that particular transaction or data. Non-repudiation means a person who has signed a document should not be able to refuse that he has signed a document later on. A digital signature performs the functions of handwritten signature using a different method. In many ways it is superior method. A person's handwritten signature at the foot of a letter does not prove that a fresh page 2 has not been substituted, but a digital signature can verify that a document is exactly the same from as when it was signed. A digital signature is different from a handwritten signature. It is unique and different every time it is generated and is related to the electronic document it is signing. So, digital signatures or electronic signatures are unique to the documents, unlike the handwritten signatures. It is created by way of a mathematical calculation on the electronic document that is being signed that produces unique numerical value known as hash results or message digest. The hash value or hash result or message digest is encrypted using private key of the sender and the resultant is known as digital signature. Digital signature is appended with the electronic document. Signed e-document is sent to the recipient. So, like we fix our ink based signature on a paper, similarly once the digital signature is created by encrypting hash value, it is appended with the electronic document. An electronic document is not encrypted, it travels in its original form. So, to make a digital signature, signer is required to generate or buy a key pair. A signer who is technically sound may create his or her own key pair and may get it registered with the certifying authority. If a signer is not competent to create key pair, then he may buy it from any of the certifying authorities. So, to make a digital signature, certain technical requirements are there. So, a user who is well versed with them, he may create and then he may send it to the certifying authority and may perform proof of possession test and may get a certificate for his public key. The idea was to adopt a technology that makes online communication and transactions legally binding. The IT Act 2000 has led to the development of digital signature regime. It establishes that principle that in an electronic environment the basic legal functions of signature are performed by way of the method that identifies the sender of an electronic record and confirms that the sender approved the content of that electronic record. any attempt to change the content of the record must be seen to be incompatible with signature. Information Technology Act 2000 is technology specific act that accepts digital signature as an authentication standard. Why do we call it technology specific act? Because it prescribes a particular technology, that is asymmetric key crypto system shall be used for creation and verification of digital signature. So any other method for creating digital signature cannot be used. So in that sense it is a technology specific act, and it is a and digital signatures are technology specific signatures. Section 3 of the act enumerates the whole process of digital signature creation and its verification. It is important that this provision should be read with the rules of certifying authorities rules 2000, especially rule 3, which talks about the manner in which information be authenticated by means of digital signatures. Then rule 4, creation of digital signature. Rule 5, verification of digital signature. Rule 6, which talks about the technological standards, like which algorithm shall be used for calculating hash value. So that is prescribed under rule 6. So digital section 3 must be read with these rules for a better understanding. Technology behind digital signature. Contrary to the popular belief, a digital signature is not a scanned image of handwritten signature. It is a block of data which is affixed at the end of an electronic document that attests the authenticity of the said document. It requires a key pair that key pair consists of private key for encryption and public key for decryption. Private key is known to the signer only, and public key may be shared with public at large. Basically, a digital signature is a two-way process involving two parties, signer and recipient, unlike handwritten signature. So digital signature is a process where at the end of the signer it shall be created, and at the end of the recipient it shall be verified. A digital signature is complete if and only if recipient successfully verifies it. Then how do we create digital signature? Suppose that if A wants to send digitally signed e-document to recipient B, then A will perform following functions. 1. A will generate a hash value by applying hash functions to an e-document. Second step would be A will encrypt the hash value with its private key. An encrypted hash value is known as digital signature. Then A will append or affix digital signature with the e-document and send it to the recipient B. So that is the creation of digital signature at the level of signer. Then second step is in the digital signature process, verifying a digital signature. Verifying of a digital signature at the recipient end involves the following steps. 1. B receives the digital signature along with electronic document. Now B will generate a hash value by applying hash function on the e-document received in its original form. So as we know that here electronic document is travelling along with digital signature in its original form. So what B shall do? B shall apply hash function on the original document, not on the encrypted hash value. Then B will decrypt digital signature by applying A's public key and recovers the hash value that was calculated by A. If both hash value obtains in step 1 and 2 are same, then the received document is authentic, that is it was sent by A only and was not tampered with during transit. Now we can also understand it with the help of graphical representation of digital signature process. So here is a message, that is electronic message. So first step would be that hash function would be applied over this electronic message and hash value will be calculated. Now this hash value will be encrypted with the help of signer's private key, and resultant is known as digital signature. Now this digital signature shall be affixed to the electronic document which is to be sent to the B. Now this will be sent through open network and would reach to B. Now B would apply the same hash function which was applied by A on the original message and would calculate the hash value. Also B would apply the corresponding public key of A on the digital signature and would calculate hash function. If both the values are same, then we can say that data travelled in its electronic in its original form and it was not tampered with, and that's how we achieve the authenticity in a electronic transaction. Conventionally signed message, for example, dear Mr. Rohit, I accept the terms and conditions discussed by us today, that, and then ink based signature is put over there. Now in digital signature it is not like ink based signature, you get some code and that is basically not in human readable format. So digital signatures for any and every other message will be different, however ink based signature remains the same for each and every document. Now legal recognition of digital signatures. Section 5 of the Information Technology Act 2000 provides legal recognition to the use of electronic signatures. Electronic signature is a wider term which was inserted by way of amendment in 2008, which includes digital signatures. Digital signatures and the role of PKI. Some certifying authority is required which certifies the association of an individual with the key pair. This association is done by issuing a certificate to the user by the certifying authority. All public key certificates are digitally signed by the CA. So a digital signature certificate shall establish relationship between the public key of the user and its digital signature. Now we shall discuss about the role of certifying authorities in the process of creation and verification of digital signatures. So as we know that when we are creating digital signature we are using a key pair, so that key pair must be issued by a trusted third party. So in this process the trusted third party is certifying authority. Certifying authorities are given a license to operate as certifying authority by the controller of certifying authorities. Controller of certifying authorities is appointed by virtue of section 17 of the Information Technology Act by the central government, and controller of certifying authorities also acts as a root certifying authority of India, and it also supervises the activities of certifying authorities and lay down necessary guidelines for them. Certifying authorities, if they are not working in compliance with the Information Technology Act, then controller of certifying authorities shall have the power to revoke their license, as well as controller of certifying authorities shall also have power to hear and determine a dispute between a subscriber and a certifying authority. Digital signature certificate, as we have already discussed, that digital signature certificate establishes a relationship between subscriber and its public key. So when we look at a digital signature certificate, then we can know about the public key value of the certificate holder or the subscriber, and here basically the certifying authorities, they certify that that public key value appearing in this particular certificate is related with or is owned by a particular person who is the holder of the certificate or in whose name that certificate has been issued. Then there is one more problem. It arises when there are two subscribers or more than two subscribers who belong to different certifying authorities within country or outside the country. So there is a concept which provides solution to this problem, that is known as cross certification approach. In this approach, trust flows between the root certifying authority of different networks. Suppose we have two networks, network 1 which is of India and network 2 which is of Japan. If root CA of network 1 wants to cross certify the network 2, then it will communicate the root CA of network 2 and vice versa. In simple words, cross certification is a process which established between the root certifying authority of two or more countries. Now the question is how digital signature is different from electronic signature. So there is a misconception that digital signature is different from electronic signature. It is not like that. Digital signature is one of the form of electronic signatures. Electronic signature is a very wide term in which any reliable technology may be used for electronic signature. However, in the context of digital signature, the technology that has been prescribed by section 3 of the Information Technology Act must be used. Any other technology cannot be used. So, any other signature which has not been created by way of asymmetric crypto system, so that may be termed as electronic signature, though section 3A states that reliable techniques shall be used. What are those reliable techniques? That shall be prescribed by the central government. Technologically speaking, there is no difference between digital signature and electronic signature. Digital signature is simply a subset of electronic signature. Both perform the same functions, that is signer's authentication, message integrity and non-repudiation. Section 3 of the Information Technology Act 2008, in order to maintain continuity with the regime of the digital signatures, has introduced the concept of technology neutral electronic signature. So, there is an allegation against Information Technology Act that this is technology specific act, and the same allegation is attributed to digital signature also, that it is also a technology specific signature. So, just to counter that, a new concept was introduced in the form of section 3A of the Information Technology Act, which states that any reliable technique may be used to sign an electronic document. Now, the question is, what are those reliable techniques? So, the power has been given to the central government, that central government shall make the rules and set the parameters for the technology which shall be used for electronic signatures and which would be reliable. Example of electronic signature may include biometric signatures, password, PIN, etc. The examples of biometric signatures means like retina verification, thumb impression and other biographical informations. Password and PIN number may also be considered as electronic signature, but here is a problem that if we are using a password or if we are using a PIN number, so can that PIN number be able to authenticate an electronic document in the manner it has been prescribed under the Act? So, for that it is required that central government must provide a framework, a parameter or a list of reliable techniques which would be used for the electronic signatures. Otherwise, that may create a confusion among the users. Now, we shall discuss about the evidentiary value of digital signatures. So, as we know that in e-commerce transactions, if the parties are required to sign a document, so that requirement of signature cannot be met with the help of handwritten signatures, because we cannot put our ink based signatures on the electronic documents. So, that is why we have the concept of digital signatures and electronic signatures. But here is a question that if an electronic signature or digital signature is being used, whether that would be acceptable to the court of law, or what are the parameters that must be followed while using digital signatures and electronic signatures, so that it should be acceptable to the court of law. So, Information Technology Act had introduced amendments in the Indian Evidence Act to suit the requirements of the digital signatures. Now, Indian Evidence Act 1872 is a part of legislation that talks about the admissibility of the evidences produced by the parties before the court. Section 65A of the Evidence Act and Section 65B of the Evidence Act talks about admissibility of electronic records. Here, what are the evidences that would be acceptable to the courts? The parameter, the guidelines have been laid down under Section 65B. So, that is for the electronic records, and if electronic record would not satisfy the requirements given under Section 65B, then it shall not be acceptable to the courts as a piece of evidence. When Indian Evidence Act was enacted in 1872, it did not envisage electronic records or electronic signature as evidence. As we know that most of the legislations which have been passed or which are in force were passed in British period. At that point of time, nobody anticipated the evolution of the computer and something like electronic commerce or e-banking. That is why the concept of digital signature, electronic signatures were not there. But with the passage of time and with the evolution of the technology, the way of business also changed and the way of record keeping also got changed. So, to meet that requirement, the Indian Evidence Act was also amended. As we can see that use of technology on a very wider level, it was felt necessary to bring required changes by way of amendments in the Indian Evidence Act 1872 to make it in accordance with changing trend in the society. Now, let us discuss some provisions of the Indian Evidence Act 1872 that talks about evidentiary value of digital signature. First, we shall discuss about section 47A of the Indian Evidence Act. It states that when the courts has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority duly licensed by the controller of certifying authorities under section 21 of the Information Technology Act, which has issued the electronic signature certificate, is a relevant fact. So, if any opinion has to be formed about an electronic signature or digital signature, then first thing that a court should look at whether it has been issued by a competent, duly recognized, duly licensed certifying authority, a certifying authority who has obtained license from the controller of certifying authority to operate as a certifying authority and its license was not revoked or suspended at the time of issuing the certificate or at the operation of the digital signature, then it would be acceptable, and whatever information value that is given in the certificate, digital signature certificate, that would be acceptable to the court because it would be a relevant fact for the court. As we know that certifying authorities gives the details of the public key value in the certificate, as well as they also verify it that the subscriber or the holder of certificate is owning that key pair. That means private key is being used by him only, nobody else is using that. So that in case of non-repudiation, it may be proved that the possessor, the person in whose name certificate was issued was in the possession of the private key, and private key and public key were working in combination. Then there is another provision in the form of 67A, which states that mere admission of execution of an electronic record by affixing electronic signature is not sufficient. Proof that electronic signature belongs to such subscriber is necessary. So, here digital signature certificate would play a very important role. So, that digital signature certificate which is being issued by a certifying authority, so certifying authority must also put its digital signature to verify the content of the digital signature certificate, and then it would be handed over to the subscriber. So, once it is certified by the content of the certificate is certified by the certifying authority, then it may be presumed that, or it would be sufficient to presume that digital signature was owned by a particular subscriber, and wherever it was used, and if any legal liability arises, so that would be incurred by the concerned subscriber. Then section 73A of the Indian Evidence Act states that the provisions of this section will apply only when a matter is pending before the court and not otherwise. It is for the court to verify whether a digital signature which has been affixed is that of person to whom it is attributed. Hence, in order to verify this, court has many options. Now, here the scope of this provision is limited. It would be applicable only if a matter is pending before the court of law, and courts shall use different methods to know that, to verify that digital signature which was used in respect of electronic message, electronic transaction or electronic document was owned by the person who was using it or in whose name it was issued. If it could be proved, then only that person would be held liable. So, for that it would be seen that that person was in the taking control of the private key, it was not compromised, and the certifying authorities which issued it was duly licensed by the controller of certifying authorities. So, if all these requirements are met, then after making this verification, court may accept digital signatures, validity of digital signatures or digital signature as an evidence. Section 85A, presumption as to electronic agreements. As we know that nowadays contracts are being entered into online, though there are various popular methods of entering into a contract like click wrap agreement, where it is very much like standard forms of contract, wherein all the terms and conditions are prescribed and a user is required to read them and then would accept it. Once he clicks on I accept or I icon or I agree icon, it becomes legally binding for him or her. So, but there are certain types of agreements where bargaining is one of the important aspect, negotiation is one of the important aspect. So, in those cases standard form of contract would not help, that means click wrap type of agreement would not help or sync wrap type of agreement would not help. So, there parties need to exchange the documents. So, suppose that two parties are exchanging the documents online, and then the requirement of the law is that it must be signed. So, now that requirement of the law can be met only with the electronic signatures or digital signatures. So, parties would apply their digital signature on the electronic agreements to sign it. Once they have signed it in the manner prescribed, then they cannot get out of their legal liabilities. They cannot say that this document is not signed, because section 4, 5, 6, 7 as well as section 10A of the Information Technology Act gives legal recognition to the use of electronic signatures and use of electronic records in electronic transactions, as well as section 10A of the Information Technology Act gives legal recognition to the electronic agreements. So, presumption as to electronic agreements, it states that if any electronic agreement is conducted by affixing electronic signature to it, then court shall presume that it is an authentic electronic document. Section 85B, presumption as to electronic records and digital signatures. So, section 85A was about presumption to electronic agreements. Now, section 85B states that unless contrary is proved, the court shall presume that secure electronic signature is attached by the subscriber with the intent of signing or approving the electronic record. It also states that there shall be no presumption related to authenticity and integrity of the electronic record or electronic signature if the same is not secure. So, now the question is, what is secure electronic signature? So, an electronic signature or digital signature which has been created in the manner prescribed under section 3 or section 3A of the Information Technology Act shall be construed as secure electronic signature, as well as section 16 of the Information Technology Act provides for security procedures. So, if that procedure has been followed, then it would be constituted as secure electronic signature. Section 85C states that presumption as to digital signature certificate. The court shall presume, unless contrary is proved, that information recorded in digital signature certificate is correct and true as well. So, if a digital signature certificate has been produced in the court of law which states that this particular public key belongs to this particular person, so unless contrary is proved, unless some flaw is discovered in the digital signature certificate or in the digital signature process, that digital signature shall be valid for all the legal purposes, and court shall presume that digital signature certificates are correct and information entered into it are acceptable to the court of law. So, the onus of proof would lie on the person who is challenging it. Now, I would like to summarize the concept of digital signature and electronic signature. Till date, use of digital signature or electronic signature is limited to electronic documents, formation of contract by way of electronic medium and electronic transactions. They are not applicable to the paper based documents yet. However, electronic signatures in combination with other security features which may be incorporated in the paper based documents may be used to sign a paper based document also. For example, if we need to apply digital signature, then we know that it is a process. So, it may be applicable on digital transactions or electronic transaction or electronic communications only. So, if we need to sign a we need to sign an electronic document which we wish to keep with us, which we wish to store with us. So, in that case, how to sign it? So, that is a problem associated with digital signature. So, digital signature and electronic signatures along with other security features which may be incorporated, it may secure the electronic documents. For example, we may take example of a currency note, like in a currency note, say 500 rupees note, there are various security features like watermarking and certain informations are given which is not visible to us. So, similarly those kind of watermarking and other technologies may be used, and then we can sign even electronic documents, and printout of that may be taken and may be preserved. So, this way we may use the electronic signatures and digital signatures for the other kinds of documents also which are not being transmitted. Thank you.